Hello, everyone. Welcome to another Agenda IDS. I am Patricia Porto, the Academic Coordinator of Dannemann Siemsen Institute. Agenda IDS is an online event in which we address important topics regarding intellectual property, law, and technology. I always invite experts on the subject to share their experience with us. And those who miss the live event will be able to access the record content available later on the Dannemann Siemsen Institute website. And today, we will debate about compulsory patent license from a BRICS perspective, with a particular focus on Brazil, India, and China. And to discuss this topic with us, we invite experts on the subject. Please, let me introduce our guests. Today, we have Ms. Manta Hanicha. Welcome, Manta. Manta is co-management partner at INTTL Advocare and holds a BSc in zoology. She leads the firm's litigation and opposition practice, bring over 25 years of extensive experience in intellectual property law. Manta has built a reputation for her exceptional expertise in patents, trademarks, designs, copyrights, and emerging technologies. She has represented top global companies across a wide range of industry in over 500 landmarks IP cases, especially representing leading global pharmaceutical companies in patent litigation. We also welcome Dr. Ning Zhang. Ning is a patent attorney at China Patent Agent HK Limited. She has a bachelor's degree in material science and engineering from Northwestern Polytechnical University and a PhD in material science and engineer from Tsinghua University. Ning's practice includes domestic and international patent law, covering patent application, administration, and litigation. She mainly focuses on industrial designs and patents in the technical field of mechanics. We also welcome Mr. Bachan Ma. Bachan is an attorney at law and patent attorney at China Patent Agent HK Limited. He has a bachelor's degrees in engineering in measurement and control technology and instrumentation from Beijing Jiantong University, a master's degree in science in electronic and electrical engineer from the University of Sheffield in UK, and a master's degree in intellectual property from the University of New Hampshire School of Law in the US. He also passed in the USPTO registration examination in the United States, and his practice includes domestic and international patent law, covering patent application, administration, enforcement, and litigation. And to moderate our event, we invite Claudia Mamede Carneiro. Welcome, Claudia. Claudia is partner at Dannemann Siemsen Institute, bachelor's degrees in chemical engineer from the Rio de Janeiro Federal University, and has a postgraduate degree in quality engineer from São Paulo University. She works with patents in the fields of chemistry, pharmacy, and biotechnology in the administrative and judicial spheres, as well as in matters related to access of genetic resource, associate traditional knowledge, and benefit sharing. And I would like to thank you very much, our guests and the audience, for being here with us today. And now I will give the floor to Claudia. Thank you so much. Claudia.
Thank you, Patricia, for this introduction. So good morning, good afternoon, and good evening to everyone joining us from different regions of the world. It's a pleasure to contribute to this important exchange of perspectives on compulsory licensing from the BRICS countries. our discussions will be initially based on some quick questions. So, what is the legal framework and legal grounds governing compulsory licensing in Brazil, India, and China? What specific circumstances these local laws permit the granting of such licenses? What is the procedural pathway and preconditions to apply for a compulsory license? And which authority has the competence to grant a compulsory license in each jurisdiction? So to address these questions, I will outline the Brazilian perspective and share some slides here. Can you see the slides? Yes, okay. So thank you so much. In Brazil, the main legal basis for compulsory licenses is the IP law, 90,279, particularly in Articles 68 to 74. Additional provisions are included in Law 14,200, enacted during the COVID-19 pandemic, and the most recent law, 15,122, which addresses international trade retaliation measures. So a compulsory license in Brazil may be granted on several legal grounds, such as the abuse of patent rights or abuse of economic power, failure to manufacture locally or to supply the domestic market properly, having an exception in case of economic unfeasibility when imported will be permitted. In case of public interest, for national or international emergency or public calamity. And finally, the dependent patent. When we have a dependent patent, I mean when a second patent cannot be exploited without using the subject matter of a prior patent, provided that the dependent invention represents a substantial technical advance and that negotiations have failed. Our law also provides provisions in case that the compulsory license will not be granted. And it will happen when there is a justification for disuse for legitimate reasons, proof of serious and effective preparations for exploitations, and in case of justification for the lack of manufacturing or marketing due to legal obstacles. The law of 14,200, it was enacted, amending our IP law, dealing with compulsory licenses of patents in the following situations: national or international emergency, public interest, or public calamity. Some conditions are that it will take place only if the owner does not meet the demand, only for local manufacturing, the product may be exported in case of pharma. And there is something very interesting, that the federal government will publish a list with potential patents, so potential patents, granted patents, and pending applications subject to compulsory license, which will be published within 30 days after the emergency, calamity, or public interest situation is formalized. Exceptions: if the patent will not be subjected to compulsory license if under a licensing agreement. And in these cases of emergency, calamity, or public interest, so there is a period, it's not forever. And as an example, we have the COVID emergency, which ended in May 2022. It's important to notice that this list may contain also pending patent applications. So pending patent applications, even before the publication, may be subjected to compulsory license. And the royalty of 1.5% on net sales are foreseen. So the most recent law, the law 15,122, it was published last month, as you can see, April, last month, and it provides the federal government with a structured framework for adopting retaliatory trade measures, including suspension of IP rights. Although this law does not create a mechanism for compulsory licensing per se, it enables such measures in exceptional cases when traditional trade remedies are ineffective. Just to bring you a brief history of this law, it was derived from the Bill 2088, which was proposed in the Brazilian Senate, and it was initially introduced to deal with only with environmental issues. There were several reviews, amendments, and it, a certain time, established a framework for Brazil to adopt unilateral retaliatory trade measures in response to foreign trade policies deemed harmful to Brazilian competitiveness, foreseeing suspension of IP rights. While this bill was not did not directly mandate IP suspension or compulsory licensing, in the end of the day, it created a legal basis for these measures. So after the reviews, this bill resulted in the law. But the most important difference, and it was a result of many discussions here in Brazil regarding the text of this bill. We succeed. We have an improvement in the text for the law, in the sense that now the retaliatory IP-related measures must be adopted only in exceptional circumstances, something very broad, and only when other measures are deemed to be inadequate to address the foreign actions, policies, or practices. So what are these other measures? It's in the law, the imposition of trade-related duties or the suspension of other commercial concessions. Anyway, in any case, the suspension of the IP-related obligations must be proportionate and aim to minimize economic and administrative burdens to Brazil. In general, a compulsory license can only be requested 3 years after the grant of the patent. And in theory, the Brazilian Patent Office is the authority competent to evaluate and grant the license. However, in cases of national emergency or public interest, the license may be granted ex officio by the federal government, and it happened with HIV cases. The patentee can oppose the license by presenting a legitimate justification for disuse or evidence of effective preparations to exploit the invention. So now let's listen about the perspective in China for the legal framework and legal grounds to compare the different practices. So Ming, the floor is yours.
Okay, Claudia, let me share our slides.
Yeah.
Is that all right? Can you see the slides?
Yes.
Okay, thank you. It's good. So I will give you a brief introduction about the legal framework about the compulsory patent license in China. The legal provisions on compulsory licensing were incorporated into China patent law when it was first enacted in 1984. And after that, they have been through three subsequent revisions in 1992, 2000, and 2008, respectively. And the current version of these provisions was finalized in 2008. Now, in China patent law, there are 11 provisions on compulsory licensing in total. That is from Article 53 to Article 63. And these articles together form the main legal framework on compulsory license. And they relate to many different aspects. And the first four articles define the circumstances that a compulsory license may be granted. And the next two articles relate to a few limitations on some special circumstances. And then there are two articles stipulate evidences that should be provided if an application for compulsory license is to be filed. And there is another one article stipulates the authority who has the power to grant the compulsory license, and also the procedure of registration and publication if a compulsory license is granted. There are two articles stipulate the rights and the obligations for the party who is granted a compulsory license for exploitation. And the last article is about the legal remedies for those who is not satisfied with the decision of compulsory license or is not satisfied with the royalty determined to be paid. So next, we will look at these articles in more details. So according to the China practice, the law permits the granting of compulsory license under four circumstances. The first one relates to patents that are not sufficiently exploited or the exercise of which is confirmed to be a monopolistic conduct. And the second one is the situation where a national emergency or extraordinary state occurs, or the public interests so require. The third circumstance is for the public health. In this case, the compulsory license can be granted for manufacture of pharmaceutical products and exporting it to the countries or regions that comply with the provisions of the relevant international treaties that China is a party. This article was actually incorporated in 2008, since China became a member of the World Trade Organization in 2001. And the last circumstances is about the patent cross-licensing. It is quite similar to the dependent patent in Brazil, as Claudia just mentioned just now. But in China, there seems to be more limitations. It requires the patent to have a major technological advancement of remarkable economic significance, which is really hard to meet the requirement. So in this case, if the exploitation of this patent depends on the exploitation of an earlier patent, then a compulsory license can be granted for the earlier patent. And also in this case, upon the request of the patent holder of the earlier patent, a compulsory license can also be granted to exploit the latter patent. And in China patent law, it is specifically defined that if the compulsory license relates to a semiconductor technology, then the exploitation shall be limited to the purpose of public interest and the circumstances regarding monopolistic conduct. And besides, except for the compulsory license granted because of the monopolistic conduct or the public health, the compulsory license shall mainly be exercised for the supply to the domestic market. And if one would like to file an application for a compulsory license of a patent, then they have to provide evidence to prove that they have made a request to the patentee with reasonable terms, but they cannot obtain such a license within a reasonable period of time. So in China, the application for a compulsory license should be filed to the Patent Administration Department, which is the China National Intellectual Property Administration, and we call it CNIPA for short. And the CNIPA will also make the decision. The China patent law also stipulates that for one who obtains a compulsory license, they does not have an exclusive right to exploit, and they has no right to permit others to exploit, and they also need to pay royalties to the patentee. The amount of the royalties can be negotiated, but if an agreement cannot be reached, then the CNIPA will make the decision. The last article is about the legal ground for legal remedies for those who are not satisfied with the decision of compulsory license or the amount of the royalties decided by CNIPA, and we will discuss this in more detail later. And at last, we would like to say that although up to now, no compulsory license has ever been granted in China, but these legal provisions still provide us with a potential tool to protect the public interest and against the abuse of the patent rights. And thank you.
Thank you very much, Ning. As we can see, we have many similarities with the Brazilian practice regarding the requirements for declaring a compulsory license, and it's particularly curious that your law has specific provisions for public health in pharmaceutical area and also for semiconductor.
Yes.
Yeah. So let's see how is this practice in India, and I invite here Manta. Please, Manta, the floor is yours.
Thank you, Claudia. It's very interesting to hear the regime in Brazil, and thank you, Ning Zhang, for explaining the situation in China. Just picking up the last point while I'm sharing my slide, is in India, there has been cases of grant of compulsory licensing and also denial of compulsory licensing. So unlike China, where there has been no compulsory licensing, we have instances where both the situations are there. So can you see my slides?
Not yet.
Not yet. One moment, just allow me, please.
Sure.
So, okay, so while I will keep on trying, you please ignore the effort which I'm trying to put the slides on screen. But in the meanwhile, I can tell you that the objective behind compulsory licensing in India is to balance the right of the patentee vis-a-vis the public right to avail the yes, it's there. Can you see here?
Yes, we can see the slides.
Okay, perfect.
Yes,
I'll make
just
it
put in the full, yes, full. Thank you.
Sorry. Just one moment. Yes, so I think it got frozen and now it's there. Okay, perfect. Sorry about it. So it's very much similar to China and Brazil. And I was trying to tell that it's a balancing act which came from 1931 from TRIPS agreement. Why did this provision came into existence is that there are developed country, there is developing country, and there were underdeveloped country. Particularly in the case of pharmaceutical, where the genesis of compulsory licensing took place, the idea was that though the patent which is granting you the exclusive monopoly for a certain period of time, but in the case where the need arises for the mankind, for the public policy or public health or public interest, there should be a provision where if the patentee is not agreeing voluntarily to grant the license to the needy or the company, there can be a provision to compel the patentee to provide such, like technology and benefit the mankind. So that was the objective. And as you can see in India, Chapter 16 of the Patents Act, 1970, this provision is envisaged. It is applicable to both product and processes, and very similar to what Anna told that in Brazil, it only becomes applicable after 3 years of grant. So there is a similarity. Now, if you see that
Yes.
this provision was also interpreted by Bombay High Court, which is the southern part of India, in a case called Bayer versus Union of India, that when and how we will understand that compulsory license will be granted, what are the requisite grounds. So as you can see that application for compulsory licensing can only be made after 3 years of grant. An applicant must make effort to obtain a voluntary license. So there has to be a positive act by the person seeking compulsory license to first make a voluntary request to the patentee, hey, I need a license for this product for ABCDE reasons, and I believe that you are not able to manufacture at an affordable price, or it is not available to the public at large, or the patent is not being worked in India. I have the capabilities and abilities to manufacture and supply to the general public. Can you give me the license? And this provision is under Section 84(1) of the Act. Now, if you satisfy both these conditions, then the controller will consider the application for compulsory licensing. So, again, my slide is stuck. Anyway, so I will go extempore. I don't think my slide is working very well. So there are 3 circumstances in which compulsory licensing can be granted, very much similar to what Anna told and what Dr. Ning Jiang said, that the reasonable requirement of the public has not been met, the product is not available to the public at large at a reasonable price, and the patent is not being worked in India. But compulsory licensing can also be obtained by government in an emergency situation, which can be a national emergency, extreme urgency, and also a case of epidemic or pandemic. So during the COVID period, there was a situation where government invoked compulsory licensing and not only supplied it to the general public, but also exported to other jurisdictions where the product was needed, underdeveloped country. So this provision was used at that point of time. And there is one more provision which is under section 92A of the Act, which says for export of patented pharmaceutical products, which means there is no domestic requirement for compulsory licensing for the public in India, but there is a requirement of other country, and the permission for manufacture of a patented compound under compulsory licensing may be given so as to make supplies to those jurisdictions, and this generally applies to underdeveloped countries. Now, if you see the procedure, what is the procedure for grant of compulsory license? I'm again trying to kind of see if I can show my slide so that, you know.
Monica, if you would like, I can share your slide that you
It's
share
okay,
with
it's
us.
moving.
Okay.
It's moving, it's moving. Okay. So yes. So if you can you see?
Yes.
Okay. So if you see the procedure for grant of compulsory license in India, the applicant should make an effort to obtain a voluntary license of the patented invention on a reasonable terms and condition. Then in case the applicant fails, application under Form 17 should be filed to show prima facie cases are met, which is again the 3 conditions which I just spelled out. If the prima facie case is not made out, then application for compulsory license is served on the patentee who can oppose this application. So what happens is he will first ask the patentee voluntarily, saying that all these conditions are fulfilled. But suppose he's able to make out a case, then he has to necessarily serve the patentee that the controller will serve the notice to the patentee that I believe prima facie case has been made out, and therefore why the compulsory licensing should not be issued, and the patentee will then file a reply. And then applicant and patentee will be heard by the controller and decision will be rendered. Now, if you see, the circumstances for grant of compulsory license in India is defined under Section 84. What are that consideration of the controller while granting a regular compulsory license? So the controller looks into the nature of invention, the time of the grant, and whether the patentee has used it or not, and also looks at the same time the profile of the applicant who is seeking the compulsory license, whether applicant's ability to work the invention for public benefit, whether applicant is financially sound and have technical capacity to take on the risk and prior attempt to get voluntary license on reasonable terms. Under Section 90, wherein the terms are laid down that the compulsory licensing, while granting the application, the controller has to ensure that there are certain requirements, which is the basis of the objective of granting the compulsory licenses are made. He needs to check into that, which is whether there is a reasonable royalty or remuneration to patent, which is being paid to the patentee on the basis of invention, nature, cost, etc. Maximal working of invention by licensee with a reasonable profit. Public access at affordable prices, because this is one of the conditions for grant of compulsory license. License can be non-exclusive. It is not that only one person can get the compulsory licensing. It has to be non-exclusive. It is non-assignable license. It's a very important point. It's suppose I am the person, an applicant seeking compulsory license. I cannot assign it to even to my subsidiary. So it is a non-assignable license. And license for balanced term of patent unless shorter duration suits public interest. So it can be the full term of the patent, whatever is remaining, or the controller may also shorten the period. Even if the patent is valid, it can be given for 1 year or 2 years, because the controller will decide the situation or circumstances may diminish after 1 year or 2 years of time. Then there are import restrictions. Licensee cannot import the patent if it would infringe the patentee's right. However, central government may allow import in case of public interest. There is also a provision where there can be a termination of compulsory license, and patentee can file an application for termination of compulsory license if it shows that there is no longer exist any need of the grounds which was mentioned for grant of compulsory license. Now, if you see the circumstances for grant of compulsory licenses in India, Section 84 says that reasonable requirement of public are deemed unsatisfied. So there's a deeming position if refusal to license by the patentee will cause prejudice to existing or new industry in India, demand for the product, export market development, commercial activities in India, and also restrictive licensing condition by the patentee if it hurts the trade industry involving non-patented materials and if the patent is not worked on a commercial scale in India. So these are the parameters which will be looked into while granting or rejecting compulsory license. Now, this is a second category of compulsory licenses which is granted only in an emergent situation. So if you see here, in India, if central government is satisfied that it is necessary for compulsory license to be granted, it may do so on national emergency, extreme urgency, public non-commercial use. In India, procedure to secure compulsory license shall not follow if the controller is satisfied that there is a case of national emergency, extreme urgency, and public non-commercial use. So as you can see, the government has a lot of powers. It can immediately, without even waiting for 3 years of time, which is in the cases of general compulsory licensing, very similar to what Anna said exists in Brazil. Again, it is stuck. So, so these are the, some of the features and the provisions under the Indian Act. I'll stop here and I will answer rest of the questions on the next round. Thank you.
Thank you so much, Manta. As we can see, we also have similarities among China, Brazil, and India. And you mentioned also an important aspect that the importance of dedicated efforts to have a voluntary licensing. It's very important to consider this before a compulsory licensing. And also the conditions to grant the compulsory license in case of public interest when the product is not available in local market in a sufficient manner. So very, very similar the situation, including the possibility of to export pharma products. So after learning about these legal grounds, let's see how about the examples of cases. Where compulsory licenses, so we saw that in China, there has been no compulsory license granted yet, but let's see the examples of licensing granted, that we have a single case in Brazil, as well as initiatives that had been taken place in the sense of having a compulsory license. Let me share my slides here. Can you see? Okay, so the first and single case that we had compulsory license granted, it was related to the pharmaceutical active ingredient efavirenz from Merck, and it was related to two granted patents. So in May 2007, Brazil issued these first compulsory licenses for the antiretroviral efavirenz. It was declared to serve public interest under the National AIDS Program. It's very strong here in Brazil, this program. Merck had 7 days to respond to this declaration. A subsequent price discount was offered by the company, but it was deemed insufficient by the Ministry of Health. The license was issued for non-commercial, non-exclusive, and temporary use with royalties paid to the patentee. So the Ministry of Health discussed that there was a big difference in the prices, as you can see. So from $59, so a discount of 30% was proposed over this value, but the government paid so $0.45 per tablet. So there was no agreement on this case. A second case was actually a discussion, an initiative for obtaining a compulsory license. It's related to the pharmaceutical active ingredient neofinavir from Roche. And in 2001, a license was announced by the Ministry of Health, but withdraw the same day when Roche agreed to a 40% price reduction. The license was again considered 2 years later in 2003, but abandoned following successful price negotiations for multiple antiretrovirals. So at that time, the reduction was achieved for 5 drugs. Besides neofinavir, we also had the lopinavir, efavirenz, tenofovir, and azatanavir. A third example is the combination of lopinavir plus ritonavir of the drug Caletra from Abbott. In 2005, Caletra was declared to be of public interest. Negotiations took place, an agreement was reached, but civil society organizations still pushed for compulsory licensing through the courts. No licensing was ultimately issued. So this case illustrates that in Brazil, the compulsory license may work as a tool for price negotiations, and we have several. So I brought 2 examples of initiatives, discussions that in the end of the day, the negotiations on prices were achieved. So now let's see about China, and I would invite Wu Tian to come to the floor.
Thank you. And I will continue sharing the slides. Yes, so before I start, here is some explanation that in China, when we talk about compulsory licensing in a narrow sense, we are referring to an administrative process where the patent office officially grants someone permission to use a patent without the patent owner's consent. But this has never actually happened in practice, as we already informed. But our courts in judicial practice have handled cases which basically achieved similar results. So when the courts find patent infringement, instead of forcing the infringer to stop using the patented technology, the court ordered the infringer to pay reasonable fees and allow them to continue using the patented technology. It is like a compulsory license in a broader sense, not exactly the administrative procedure, but ends up serving the same purpose. When the court makes these rulings, They are mainly following the two principles from the Supreme Court's order and spirits. The one is significant imbalance of interest between the parties, and the other one is public interest. For example, as shown in these slides, this is a Supreme Court judicial guidance announced in 2009, and it states that if seizing the relevant act would result in a significant imbalance of interest between the parties or be contrary to the public interest, instead of ruling to seize the act, alternative measures such as more substantial compensation or economic indemnity may be adopted. And similarly, some Supreme Court judicial interpretation also have cited the similar rules. Like here, it is said that the court may order the defendant to pay appropriate, reasonable compensation instead of issuing an injunction under the consideration of national interest or public interest. And here are a few cases I would like to share. In the first cases, in this case, a power plant company was using a special equipment to filter out harmful sulfur dioxide from its exhaust gases, which turns out to be someone else's patented invention. The court recognized that the power plant company used the patented equipment without the patentee's permission, but the court refused to rule shutting down the power plant. The court believed that shutting down the power plant would be a bad idea because it will harm the local economy and public welfare, especially considering that the infringing equipment is actually aligned with the national policy of environmental protection. And as a result, the court ordered the defendant to keep using the equipment, but pay the patent owner a regular royalty until the patent expires. So it shows that the court prioritized clean air and community needs over strict punishment. And here is another case. In this case, an airport used curtain wall connectors in its construction, which turned out to be a patented technology. And the court agreed that it has already constituted patent infringement, but the court did not force the airport to replace all those walls because such order will cause massive cost and affect the basic needs of the public for transportation. Therefore, the airport was allowed to continue using the infringing device upon paying reasonable fees. And this is a classic case of prioritizing public interest over strictly enforcing the patent rights. So as you can see, in these two cases, power plants and airports are not just ordinary business. They are essential public service which we rely on basically every day. And if the court forced the infringer to stop using the infringing technology, large-scale reconstruction is needed, which will result in huge costs. And the judge basically says, like, look, we get that the patent owners deserve protection, but shutting down the critical infrastructure hurts everyone. So let's make this implementer pay fair compensation to the inventors and keep the factory and the airplanes running. So it is all about finding the balance, respecting the innovation by ensuring the inventors get paid, while keep the society's basic needs. Yeah, that's the cases I would like to share, and I'll stop here.
Thank you very much, Putian, for bringing this example. And as I guess that it's very important to highlight here the importance to make a balance aiming at protecting and incentivizing innovation, respecting and the innovations, and that negotiations such as payment of royalties, any kind, so any form, any way to have a negotiation aiming at having a balance in the market. So now let's see the examples that we have in India, Manta, please.
Thank you. Yes. So as I said in the very beginning that I have 4 cases to discuss. In one case, which is Bayer versus Union of India, compulsory license was granted. And in 3 cases, compulsory licenses were denied. And I will take you through why it was granted and why it was denied. So if you see here, this was a case of 2014, so quite almost 10 years back, for a drug, Nexavar, which is for the treatment of kidney cancer. A request for compulsory license was allowed by the controller of patent, and an appeal was filed before then IPAB, now it is abolished, and the matter went up till the court of Bombay High Court and also till Supreme Court. But before I talk about what happened in Supreme Court, let's look at why this was granted. So one of the conditions that prerequisite of efforts to obtain voluntary licenses were met. As I said in the beginning, that the applicant who is seeking compulsory licensing has to first request for grant of compulsory licensing. That was met in this case. But there was an admission which was made by the patentee that only 200 patients received the medicine out of 8,000. So therefore, the court took a view that reasonable requirement was not met, admittedly in this case, as patentee itself admitted this. And non-availability at a reasonable affordable price was also made out. And therefore, if you see, adverse inference against patentee were drawn because it did not produce the evidence of expenditure and earning available with the patentee. Direction to produce balance sheet was opposed. The patentee declared that it is an orphan drug by the US government and it is entitled to patentee reimbursement of the 50% of research expenditure. That figure was also not disclosed, whereas the drug price was almost 2 million according to Indian currency, 2.8 million per month of therapy, whereas the genetic drug available was, you can see, less than 0.1%, so per month of therapy. So there was a huge difference in the price, and patentee failed to provide expenditure and earning justifying the cost. So the second condition, it was held that generic drug not available to the public at reasonable affordable price, and therefore the compulsory license was granted. It was also held that the product was being imported, though in India import amounts to working, but there are certain reasonable grounds which needs to be established, which the patentee failed to establish in this case. And the Supreme Court, the matter went up till Supreme Court, and Supreme Court refused to interfere with the grant of compulsory license. This is the only case wherein compulsory license was granted. After that, we witnessed 3 cases where compulsory licenses were denied. And these cases were, one of the case was of Roche of the year 2013. This was for trastuzumab, which is a drug for Herceptin. Under section 92, it was applied, saying that it is a case of national emergency and the government must notify it. The another wing of government, which is Department of Industrial Policy and Promotion, denied the fact that it was a case of any national emergency. And therefore, the two government said that, it is not a case of, like national emergency. It is a case which is trying to be built by the applicant who is trying to seek compulsory license, and therefore it was denied. The second case where it was denied was in the year 2013, where Bristol-Myers drug was dasatinib and compulsory license was applied for that. The claim was rejected by the controller of patent since this BDR, which is BDR Pharma, had not made reasonable effort to obtain voluntary license. So this is one of the conditions. As you saw in the first case, in Bayer case, this criteria was met. But here, the applicant never approached the patentee for grant of a voluntary license. And therefore, this is a mandatory requirement. If you don't seek voluntary license first, and unless it is denied by the patentee, you cannot go for compulsory licensing. So that condition was not met, and hence primary requirement was not satisfied. Lastly, this is a case of Lee Pharma versus AstraZeneca. AstraZeneca had a patent for sitagliptin, and Lee Pharma, sitagliptin is an anti-diabetic drug, and Lee Pharma applied for compulsory licensing on the grounds that price of the drug was beyond the reach of the buyer, and there is a lack of adequate availability of the drug in India. The controller of patents refused to entertain the compulsory licensing application for the reasons that Lee Pharma had attempted to secure voluntary license. This condition is made out, however, there was no evidence was produced that the public requirement was not satisfied, whereas there were several other substitutive drug, there was a lot of substituents. So there was ligagliptin, there was vildagliptin, there was so many other gliptin which were available in the market. And therefore, it was not a case where the public requirements were not being satisfied by an alternative drug. Then the next point was that no appreciable difference in current price of drug and applicant's proposed selling price. So applicant also failed to show that the drug was so expensive that it is not affordable to the patient, and the price which was quoted by the applicant was matching with the patentee's price. And local manufacturing is not always a prerequisite to establish working. No data was provided to show that the patent is not being worked. So as you can see that in India, the cases are examined very strictly following the grounds and the criterias for which is envisaged under the Act, and the applicant seeking the compulsory licensing has to fulfill those criterias, make the case, submit the evidence, and then alone, in a certain cases, compulsory licenses can be granted. I just also wanted to add here that, like China, in India also, it's not limited to pharmaceutical. You can also seek compulsory licensing for semiconductors, but there has been no case for seeking compulsory licensing for semiconductor. All the cases, as you have seen, has been in the field of pharmaceutical industry.
So thank you, Mamta. So as you can see, the discussions on compulsory licenses are in India are focused on pharmaceutical area, as in Brazil. And it's also curious that in India there are conditions that are also specification on the semiconductor. It's also a very important technical area, but in India, no concrete case on this area. We will also see the importance of the evidences, either to have the compulsory license declared or to challenge this declaration of compulsory licenses. So we see that it involves extensive negotiations, and the price is one of the most important aspects. As a reference here in Brazil, we have an entity called CADE. It's an administrative economic council that is responsible to regulate the prices of the drugs. So the price of the drug is submitted to analysis and to approval firstly. So let's see, as a final comment here regarding when a party is not satisfied with this compulsory licenses. So what can be done? Let me share my slide here. What can be done? So the remedies. How about the remedies? Negotiation is part of this process, as we can see based on the examples provided. And if the negotiations does not solve the situation, a court action may be filed seeking to invalidate the compulsory licensing. The patentee must demonstrate that requirements for compulsory licenses were not fulfilled. And also there is the possibility to challenge the term and royalties established in the compulsory licensing through a court actions. So these are the mechanisms that we have to preserve the rule of law and ensure the process in decisions affecting patent rights. So I would invite again Butian to make a brief comment regarding the remedies.
Thank you, Claudia. And I think the practice in China is pretty close to what is happening in Brazil. Like, well, under the Chinese law, the judicial remedies are available for both parties satisfied with the compulsory licensing decisions, including that the patent holders may challenge the grant of the compulsory license or challenge the licensing fees. And the licensees may also dispute the fee determinations through the judicial proceedings. But it should be mentioned is that applicants seeking compulsory license fees limitation that if the patent office reject the application for compulsory licensing, the applicant cannot challenge the decision before the court. That means the remedy is unilateral, and I believe the possible reason is that the court or the law want to reduce the procedural complexity or encouraging the negotiation between the patent holder and the implementers. So that is about the remedy. As we already explained that in China there is no actual case about compulsory licensing. Well, I mean the compulsory licensing in narrow senses has ever happened before. So we currently may not know what will actually happen before the court if somebody raised an opposition about the order of compulsory licensing and file to the court. Yeah, that's the what I would like to share. Thank you.
Okay. Thank you, Ning. And Manta, how about in summary, the remedies that you have in India?
So in India, it's very similar to Brazil, I would say, because any aggrieved party, whether it is the applicant for compulsory licensing or the patentee, can reach to High Court directly or can even go to Supreme Court directly, because we have two provisions. You can go to High Court, you can go to Supreme Court. However, in our experiences so far, everybody has gone to High Court and then gone to Supreme Court, because nobody wants to lose that one more, kind of a space where you can, one more opportunity to kind of take it forward. Because if you go to Supreme Court, which is the highest judicial body in the country, so people generally go to High Court and then go to Supreme Court. But strictly speaking, as per law, you can go to Supreme Court directly or you can go also to High Court.
Thank you, Manta. So if the plan A of having voluntary license doesn't succeed, and if finally a compulsory license is declared and granted, there are tools before the courts in all in our jurisdictions to challenge this compulsory license. So let's move on to the questions. We have a question here to Ning. And the question is, could you please demonstrate what Chinese court considers significant fees? So this is a very broad term, but let's see what Ning and Bhutia may help us in clarifying this question.
Okay, thank you, Claudia, and thank you for the question. Firstly, I have to explain that the grant of compulsory license in China is conducted by the Patent Administration Department, and the Chinese court is not involved in this procedure. And I'm not quite sure what is the significant fees, because I can't remember I mentioned that. But I think it might be related to the remarkable economic significance that I talked about in the patent cross licensing. If that is the case, firstly, I have to say that as there is no actual practice in China now, so we do not know how the administration department will consider the patent to have a remarkable economic significance. But according to our experience and some similar cases in other sections of China patent law, we may provide evidence that this patent can greatly reduce the cost or can greatly enhance the efficiency of the production, or could achieve a business success. And so we may provide evidence to prove that. And I hope I answers your question.
Yeah, well, thank you, Ning. We have another question here, I guess for all three countries. We have been receiving many questions, and so in case we are not able to have enough time, we will contact to revert with replies to this question. We have another question that is, in the cases discussed in the three jurisdictions, what were the royalties agreed? How were they calculated? So Manta, would you like to comment on this question?
Yes, so depends on the facts and circumstances of the cases, but generally the royalty can range from 3% to 6%. That is an average case, but there can be a situation where the drug is so expensive and the need is so imminent that government may, the controller may reduce it even to 1%. So it all depends on what is the situation and what is the public interest demands in a given situation, you know. So for example, we talked about orphan drug, you know, and rare disease, where it becomes generally the rare disease are very expensive medicine, and rightly so, because patentee has really invested a lot of money thinking that it will be able to recover. But rare disease, as the name suggests, the population and the patient population is so small that the demand of the product is less. And the patentee is not doing a charity. Patentee has to recover that amount from the market so as to invest for the new invention. In such cases, it becomes a very tug of war. But if the public interest prevails and the situation demands, it can be a very less royalty as well. So there is no fixed formula. It is very dependent on the facts and circumstances of the case.
Yes, so thank you, Manta. I guess you summarized it very well. The situation here in Brazil is similar, but to give a reference in terms of royalties, general from 1 to 7%, depending on the technological area. and also as a result of negotiations and the real need for the country. Butian Ning would like to please comment some.
Yeah, thank you. I explained two cases regarding the decision related to compulsory licensing issued by the court instead of the patent office. And in the Chinese legal framework, regarding the amount of damage or compensation, generally speaking, the legal framework is that firstly, we want to determine what is the benefits obtained by the infringer. And if it cannot be calculated, we can also determine what is the loss of the patentee. And if both of them cannot be determined, we will refer to the reasonable license fee that happens before. But as you know, apparently when we're talking about compulsory licensing, apparently no license has happened before. That makes it compulsory. So this makes the third one also unavailable. So the last one will be a judicial decision on compulsory on the compensation. That means the court will make the decision about the damage or about the royalty under its own discretion. And in the two cases I explained here, basically it's about the damage or the royalty is about 40,000 to 50,000 in each cases. But well, as Manta explained, every case depends on its own facts. And in the case I shared, it's about public affairs. It's about a plant and an airport. So the situation is about this amount, but I'm not sure if there will be a case regarding to the pharmaceutical industry, how the court or the patent office will calculate what is the royalty should be.
Okay, thank you, Butian. So in the name of the time, so we have still other questions that we will revert with by email to other questions. And so Patricia, the floor now is yours for
Ending
just
the
finishing the end of our webinar. Unfortunately, we have many things to discuss, but the time is in advance.
Thank you so much, Ana Cláudia. Thank Ning, thank Buchan, and thank Manta for the lecture, the wonderful lecture you gave us today. And would like to thank the audience and invite the audience to follow the Dannemann Siemsen Institute in our social medias and website, because each month we have new webinars and new materials to provide for you all. And so I'm finishing this event, very happy, and thank you all. Bye-bye.
Thank you. Bye.
Bye. Thank you. Bye-bye.
Thank you.